You ready? Wherever you are. Hey guys, welcome. Happy to have you here, everybody on Zoom as well. Pleased to introduce our guest for this afternoon. We have with us Judge Phillip Calabrese, Northern District of Ohio, Federal Court. Judge Calabrese comes to us. He's a graduate of Holy Cross, where he graduated. He's a Fulbright scholar, and he's also a graduate of Harvard Law School. He's been on the court since 2019 and was nominated by President Trump with bipartisan support, my add. And he's here today to speak to us on behalf of habeas and the rule of law, and hopefully answer a few questions for us at the end. So I'm going to turn the floor over to the honorable judge.
All right. Well, good afternoon. Thanks for the opportunity to be with you today. And there's a few different things could have talked about. I gave a menu to the organizers and they picked this one. So it is timely. And so it's worth taking a little bit of time to talk about it. The basic thesis here is called the Habeas Corpus and the Rule of Law, focusing specifically on the Sixth Circuit. Habeas is one of these areas that you don't necessarily cover in law school. It's incredibly difficult and challenging in all the right ways. So if you're lucky, you'll get the opportunity to do some work in that space. But because it's not really talked about in law school, let me just provide a little bit, as briefly as I can, some background to orient everyone. So first, what is habeas corpus? So it used to be the case, hopefully in the past and not going forward in the future, that government officials of high rank would have their personal and political opponents and enemies arrested and jailed and hold them indefinitely. In our political tradition and in our moral system, we have come to believe two important things. One, that a person ought not to be punished or imprisoned unless they have done something wrong. And two, even a person who has done something wrong cannot be punished justly or imprisoned unless society has made clear upfront that the act in question is wrong and subject to punishment. These principles are the foundation of the rule of law. They lie at the heart of our system and trace back to Magna Carta, and ultimately give rise to the writ of habeas corpus. The writ of habeas corpus is a written judicial demand. It's a court order to a government official directing that official, who is the warden or jailer, to produce the person in custody, to deliver generally his body for a particular purpose. And historically, that purpose was to investigate whether the prisoner was lawfully detained. For this reason, our courts described the writ of habeas corpus as a, quote, bulwark of liberty against unlawful imprisonment, and it lies at the heart of our system. In our Constitution, the suspension clause secures the writ. It provides that the privilege of the writ of habeas corpus shall not be suspended unless in cases of rebellion or invasion, the public safety may require it. The suspension clause protects the writ as it existed at the time the Constitution was drafted and ratified, but it does not, by its own terms, authorize federal courts or any court to issue a writ of habeas corpus. It just protects and secures that writ. Instead, the power to award the writ has to be given by Congress, and the judgment about the proper scope and circumstances under which it will issue are for Congress. The Judiciary Act of 1789 granted federal courts authority to issue writs of habeas corpus. Other laws passed in the intervening 200 and almost 50 years now have modified, supplemented, and reformed habeas practice and procedure. So of particular relevance here is an act, the Anti-Terrorism and Effective Death Penalty Act of 1996, also known as the AEDPA. For our purpose, in this context, habeas corpus, or the writ, refers to the legal concept of a state prisoner challenging his state court conviction in federal court by claiming that the state court violated the Constitution or a federal law. These claims are brought under 28 USC section 2254. There are special legislatively enacted procedural rules, the federal rules of habeas corpus, that also govern the writ. On the whole, the writ is equitable in nature, and it seeks to vindicate the interests of federalism, comity, and finality. So let's talk for a moment about section 2254. Under the statute, the AEDPA, the federal court may grant a writ of habeas corpus to a state prisoner on a claim that was adjudicated on the merits in state court only in two limited and enumerated circumstances. Writ may issue only if the federal court concludes that the state court adjudication resulting in a judgment of conviction, one, resulted in a decision that was contrary to or involved in unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or two, resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceedings. That's at section 2254D. The overwhelming majority of habeas cases involve those two provisions, and the first one in particular, whether a state court decision is contrary to or involved in unreasonable application of clearly established federal law as determined by the Supreme Court. So let me focus on that first one. The contrary to clause in section 2254D1 authorizes a federal court to grant a writ if the state court arrives at a conclusion opposite to that reached by the Supreme Court on a question of law. As you might imagine, that's not going to happen very often at all. Or if the state court decides a case differently than the Supreme Court does on a set of materially indistinguishable facts. Under the second half of 2254D1, the unreasonable application clause, the federal court may grant a writ of habeas corpus if the state court identifies the correct governing legal principles from Supreme Court law and decisions, but unreasonably applies those principles to the facts of the particular petitioner's case. Under this standard, the Supreme Court has long held that a federal court may not issue the writ simply because that federal court concludes in its independent judgment that the relevant state court decision applied clearly established federal law erroneously or incorrectly. The state court must act unreasonably. So in other words, and in short, if the state court has addressed a prisoner's claim, Congress has limited the power of the federal courts under 2254D1 to grant relief on a claim, and a federal court may do so only if the state court's resolution of the claim was unreasonable in some way. One last important point by way of background, even then, where a state court has acted unreasonably and violated a petitioner's constitutional rights in doing so, the petitioner is not entitled to a writ of habeas corpus unless that violation was not harmless. That is, that it was prejudicial in some way, that it made a difference in the state court proceedings. Habeas relief is extraordinary. It involves the courts of one sovereign, in this case, our national government, adjudicating the decision of the courts of another, state courts. But under Article 3 of the Constitution, the state courts are presumed to be as equally capable of vindicating federal constitutional rights as the federal courts. And so this is hence the interests of comity and federalism that come into play. So that's a very quick background, and it's of course way more complicated than that. But let me talk about a specific case that got me thinking about these issues, and it's a case called Smith v. Eppinger. Let me give you the factual background of this case. This involves a woman named Courtney Tolliver. Courtney Tolliver was a drug dealer not far from here. One day she had a court hearing. She called a friend of hers and asked for a ride home. Instead of the friend, somebody else picked her up, a gentleman named David Smith. He was driving the car. They then came to Cleveland. They bought some crack from a friend of Tolliver's. A few weeks later, Smith and Tolliver connected again. They texted back and forth over the course of the day and into the night about acquiring some drugs. Those texts include haggling about the price. Tolliver interpreted the texts as demanding a deal on the drugs. Around 11 p.m. that night, Smith texted Tolliver that he would see her tomorrow. The next morning, the texts resumed. Around 9 a.m., Tolliver told Smith that she needed a ride to Cleveland to get the drugs that Smith wanted. Then at trial, ultimately, the evidence showed that Tolliver planned to travel back to Cleveland to get crack for Smith. And consistent with that plan, Smith texted at 10 a.m. that morning that he would go pick her up. He texted her at 10:40 to see if she was ready. And what happens next is the core dispute in this case. Tolliver was attacked in her home. She sustained very serious injuries, including skull and facial fractures. She testified at trial that when she turned her back to the door to put her shoes on, she felt a blow to the back of her head and blacked out. She regained consciousness long enough to get outside of the house where a neighbor saw her and called the police. When the police arrived, Tolliver's home was covered in blood, and there was a hammer in the kitchen. For about 2 weeks after this attack, Tolliver was hospitalized and kept in a medically induced coma. Police started to investigate immediately. Obviously, she's in a coma, and so Tolliver cannot help the police, but they do track down her cell phone. They get a subpoena to the cell phone company for access to the phone, and they find the one number that had been communicating constantly with her in the days leading up to the attack. And of course, it belongs to David Smith. They too had texted or called 85 times in the span of a 24-hour period. They're able ultimately to trace that number to Smith. Other aspects of the investigation also pointed to Smith as a suspect. There was cell site location data for Smith's number on the day of the attack, showing him leaving where he lived, traveling to Tolliver's residence where she was attacked, including communications with a cell tower near her house at about the time of the attack. There was also DNA evidence of Smith at the scene. There was some blood at the sink that traced to Smith. Now, that DNA evidence was not particularly of the quality we might ordinarily think for various reasons. Still, there was one sample had a 1 in 3,914 chance of being someone other than Smith. One had a 1 in 155 chance. Not great, but also not nothing. And there was a witness who testified that he saw Smith around the time of the attack near Tolliver's house. When Tolliver comes out of her coma, she was unable to speak for a time due to her injuries, but she was able to communicate by writing and nodding her head and things like that. So law enforcement presented a photo array to her, asked her if any of the people she saw were the person who committed the attack, and she said no to every one of them. Smith was not in the photo array. When she came out of her coma, Oliver, for her activities in these drug transactions, was facing charges. She was facing criminal charges, which becomes an important fact here. She told detectives that she did not remember the attack. While she was recovering, a detective visited her. Her mother was present at the time of this visit while she's in a nursing facility recovering from the attack. There's a recording of the conversation. The detective says, quote, "I think I found out who did this to you." He shows Tolliver a photo of David Smith. She says, "I don't recognize him," and asks who she was. And then later says, "Oh yeah, I remember I gave him a ride to Cleveland one time." The detective, using a fairly standard law enforcement technique, says, "Well, it's funny you don't remember him because he remembers you and he doesn't have anything good to say about you. Remember, you're facing criminal liability, by the way." And that he says he's found all of the text messages between the two of them. That prompted Tolliver to remember that Smith, on the day of her attack, was supposed to give her another ride to pick up some drugs. And then she says, "But I don't remember anything clearly from that day." Not surprising, right, for anybody who's had an episode like that. But she does tell the detective that while she was unconscious in a medically induced coma, she had a dream. She's not sure whether it's a dream or a memory, but she thinks in the dream Smith was in her home and that she was hit in the head with a hammer before she eventually was able to get out and make it to her friend's house. But she was not clear whether it was a dream or a memory. Once those drug charges are resolved against her about 4 months later, her story changes. Then she's able to recall details quite clearly. And she was able to explain what happened on the day of the attack. And she was able to say that was not a dream, it was an actual memory. And she was able to identify Smith as her attacker. Smith, before he stands trial on charges up to and including attempted murder, moves to suppress the identification. He argues that the detectives' identification methods were unduly suggestive and unreliable. And ultimately, after a hearing, the state trial court denies the motion to suppress. Notably, there's a Supreme Court case on point here, going back to our 2254 D1 standard. There's a case called Neal v. Biggers, which we'll talk more about in a moment. And in ruling on the motion to suppress, the state trial court does not mention or cite this case. Under Neal v. Biggers, an identification violates a defendant's right to due process under the 14th Amendment, where the identification procedure was so unnecessarily suggestive as to run the risk of an irreparable mistaken identification. The Supreme Court directs courts to engage in case-by-case assessment of the totality of the circumstances to determine whether improper police conduct created an impermissible risk of misidentification. After making that assessment, courts should suppress the identification if it is unreliable, and reliability is the linchpin. The central question under the Supreme Court case law is whether under the totality of the circumstances, the identification was reliable, even though the confrontation procedure was suggestive. And then there's a list of factors that the Supreme Court asks courts to consider when applying this analysis. So then after rejecting the motion to suppress, but not citing Neal v. Biggers and the case law under it, a jury convicts David Smith of attempted murder, felonious assault, aggravated robbery, and aggravated burglary. The state trial court sentenced him to a total term of imprisonment of 23 years. On direct appeal, Smith argues that the trial court erred by denying the motion to suppress based on the identification of him, the circumstances I told you about. The state appellate court ruled that the state trial court did not err. This was a 2-1 decision. The state trial court concluded that the detective's procedure for identification was in fact impermissibly suggestive. Why? Because he made repeated disparaging statements about Smith and told Tolliver about evidence linking Smith to the scene before she conclusively identified him. However, the Court of Appeals applied Neal v. Biggers, expressly cited it, discussed it, and held that the identification was otherwise reliable under the totality of the circumstances because Tolliver was already familiar with Smith, had ample opportunity to see him on the day of the attack, and was not suffering any resulting physical impairment at the time she saw him that would have interfered with that identification. The state appellate court found that this was a strong showing of reliability and on the totality of the circumstances found no violation of the right to due process and held that suppression was not required. The Ohio Supreme Court declined to review the case. So that brings us at long last to federal court. Smith filed a petition for a writ of habeas corpus. The federal magistrate judge issued a report and recommendation reviewing the record, the evidence, the 2254 standard, and so forth, and recommended that the court deny the petition for a writ of habeas corpus. The petitioner objected. As you probably surmised, I was the trial judge in this case to whom the petition was assigned, and I adopted the magistrate judge's report and recommendation. Why? Because fundamentally, whether the state trial court cited the correct Supreme Court decision or not is not dispositive. In fact, the Supreme Court repeatedly says the state courts don't even have to know about the name under 2254 of the controlling Supreme Court precedent, so long as they discuss the appropriate principles. What matters is whether the overall state adjudication is contrary to or an unreasonable application of clearly established federal law as determined by the Supreme Court. That controlling precedent is Biggers. In my view, the state appellate court correctly identified that. You don't review the state trial court. You don't review the state Supreme Court. You review the totality of the adjudication from the state courts under 2254. And the precedent from the Supreme Court, Neal v. Biggers here, made perfectly clear that when the state appellate court discussed the record on direct appeal, correctly cited Neal v. Biggers and applied it, the only question is whether that was a reasonable application or not, and I could not say that it was not. I did certify the case for appeal to the Sixth Circuit, and let me just say a word about that. There's no right to appeal if you're a habeas petitioner, unless the district court who denies your relief also says you may appeal. Under section 2255, 53, I should say. On appeal, the Sixth Circuit reversed me. Now, we can talk about what that's like. I don't overall much care whether I get reversed or not. There's some times where it's grateful. There's other times where I disagree. But let me tell you what the Sixth Circuit did here. As the majority, Sixth Circuit majority saw it, the Ohio courts failed to engage in the balancing test mandated by clearly established Supreme Court precedent. That's a direct quote from the majority opinion. The majority faulted the Ohio courts for not balancing what it called an extremely weak showing of reliability against the immensely suggestive law enforcement procedure. In the majority's view, Tolliver's identification served as the key piece of the government's evidence. So failing to suppress it meant that any fair-minded jurist would conclude that the scale crashes to the side of granting habeas relief. There's a couple problems here as I see it. First is that the Sixth Circuit simply disregarded the other circumstantial evidence of Smith's guilt. It ignored the ruling of the state appellate court, which expressly did what the Sixth Circuit majority said it did not do. The State Court of Appeals directly applied the controlling Supreme Court precedent. The majority might not like the balancing that that state appellate court did, Clearly, the Sixth Circuit does not like that result, but that's not the governing legal standard. That's not the question. The question is not whether in the exercise of its independent judgment, the federal court would reach a different conclusion than the state courts. The only question under 2254 D1 is whether the state appellate court unreasonably applied Neal v. Biggers. There was one dissent on the Sixth Circuit court. Judge Tapar dissented. He noted three serious problems with the majority's application of the AEDPA, and I'll just focus on one. The dissent described the majority as a, quote, de novo analysis of the factors under Neal v. Biggers that merely asserted that no fair-minded jurist could disagree with its conclusion. In that regard, in my view, Judge Tapar is unquestionably and undeniably right. The panel majority did nothing other than directly review the judgment from the State Appellate Court of Ohio, and that's not what federal writ of habeas corpus is. That's not how our parallel systems created, established, and run by two separate sovereigns work in general, let alone under the congressional restrictions and strictures for issuance of a writ under the AEDPA. All right, so that takes me to the heart, I suppose, of what I wanted to talk about today. This is not a high-profile case. This is not one you've probably read about in the news. As far as I know, it's never been in the news. I've never gone to check. It's not a capital case. Those do tend to end up in the news. And I think we can all agree, whatever one feels about capital cases, they are important and significant cases. But for some reason, and I've actually spent a lot of time trying to figure out why, but the Sixth Circuit's decision in this case is one that has bothered me more profoundly than almost any case I've read from the Sixth Circuit. And going back to the time I clerked there, I've seen some pretty disturbing decisions from the Sixth Circuit over the years. But for whatever reason, this is one that I've not been able to get out of my head. I'll emphasize, it's not because the court reversed me. There's times where I've been reversed, I don't care. There's times where I've been reversed, and I think the Sixth Circuit got it right, and I think I got it wrong. So we can talk about that if you want. But trying to work through why this case bothers me so much is kind of why I started thinking about this and ultimately put together these remarks. Probably the best way I can explain my thinking on this to you is to tell you what I wrote based on the Sixth Circuit's decision in this case. So let me just give you two other pieces of background by way of context. First, the respondent, the state of Ohio, effectively moved to stay the issuance of the mandate from the Sixth Circuit. And the Sixth Circuit summarily denied that without any explanation. Second, the Sixth Circuit issued its decision last summer. When it did so, it concluded its decision with the following instructions. It gave instructions that the district court issue Smith a writ of habeas corpus unless the state proceeds within 180 days to prosecute Smith in a new trial without using Tolliver's identification of Smith, which shall be suppressed and excluded from evidence. So with that mandate, those were my instructions from the Sixth Circuit. So on September 20th, 2024, I issued a conditional writ. The conditional writ is that the state must retry Smith within by March 13th, effectively. So we're coming up on that here shortly, without the identification. So here's part of what I wrote. I won't read all of it to you, but I did issue a conditional writ advising everybody of the March 13th deadline. Five federal judges have reviewed the record in this case to determine whether the identification of petitioner David Smith was unnecessarily suggestive, resulting in a conviction that violates his federal constitutional rights. Three of those judges agree that the identification, while perhaps not the best police work, did not result in a conviction that violates the Constitution. 2, who happened to form the majority of the 3-judge panel at the Sixth Circuit, see the case differently. But even a cursory review of their reasoning shows that relief may issue in this case only by disregarding the narrow and limited circumstances in which Congress authorized the federal courts to set aside a state court conviction, see 2254D. After all, the record shows that the state courts expressly discussed the Supreme Court precedent in Neal v. Biggers, which controls. Under the AEDPA, then, a writ may issue only if the state court's decision involved an unreasonable application of that precedent. As an aside, even the panel majority did not suggest that it was contrary to Biggers. Whether one agrees or disagrees with the decision of the state courts, that decision did not unreasonably apply the Supreme Court's clearly established precedent. In its haste to issue a writ, I said the panel majority compounds its fundamental misunderstanding of the AEDPA's governing standard with at least 2 unusual procedural moves. First, the Sixth Circuit fails so much as to mention harmless error, let alone remand for that analysis. The principles of federalism and comity embodied in the AEDPA would seem to counsel at least a mention of the issue. Second, the Sixth Circuit panel majority appears to try to insulate its decision against further review. When issuing a writ of habeas corpus that might well result in the release of a person convicted in state court of a serious violent offense, the court ought in fairness to publish that decision for the state, the inferior federal courts, and others to see. The panel did not do that. More significantly, the Sixth Circuit denied respondents' motion to stay the issuance of the mandate to allow time to seek further review. If the panel had confidence in its substantive ruling, it would welcome scrutiny. And time is not of the essence in light of the 23-year sentence Smith received. What appears as a routine denial of a motion to stay has subtle and pernicious effects. The Sixth Circuit remanded with the instructions I already read you. That mandate leaves the district court, me, no discretion to consider harmless error or any other issue that might in any way modify the outcome under proper understanding of the AEDPA. Moreover, by its terms, the mandate contains no language deferring its effective date until after any further review or entry of the final non-appealable order. Therefore, under the law, the 180-day clock for the state to try Smith began to run on September 12th when the Sixth Circuit issued the mandate. Nor does the court, the district court, have authority to issue a stay pending cert because of the language of the mandate. Even the most experienced Supreme Court practitioner might miss some of these technical intricacies, resulting in the issuance of a writ before the state has had the opportunity fairly to consider and pursue its options for either for further review or to retry Smith. So then I issue the writ. But let me just conclude, and then we can turn to questions either about this or anything else you all want to talk about today. I'll just conclude by making 2 last points. First, what the Sixth Circuit did in this one somewhat unremarkable case, unfortunately, in my view, is par for the course. I wanted to present to you some data to back up my opinion on that. I did spend a considerable amount of time trying to find data on reversal rates at the Sixth Circuit and habeas and things like that, and it proves remarkably difficult to find. So I did something that probably Cleveland State would not want you to do, and this is, I will tell you, this is the only time I've used AI. So I asked AI a question. I asked, which circuit has the Supreme Court reversed the most in habeas cases? And this is what AI tells me. According to available information, the Sixth Circuit is considered the circuit that the Supreme Court has reversed the most in habeas corpus cases, with a significant portion of those reversals occurring when the Sixth Circuit granted a habeas petition, often due to perceived misapplication of the AEDPA. So don't take my word for it, take AI's view of it. It also took about a minute or less to figure that out from AI after I'd spent about an hour trying to find the actual statistics and data. I only take a little bit of comfort from that because I gave this talk one other time and a professor came up to me afterwards and said he had been trying to write a paper on the same point and couldn't find the data after spending a couple months on it. So if you don't trust AI, I would encourage you not to trust AI. I'm not sure I do. Let me give you a better human source, not a confidential human source for those of you in the business, an actual human source that will validate that statement. Respondent did petition for a stay at the Supreme Court, which denied the stay, and then asked on an expedited basis for a writ of certiorari for discretionary review at the Supreme Court. The Supreme Court also denied that, but Justice Thomas dissented from the denial of review, and Justice Alito joined him. And Justice Thomas made the following observation in the course of his dissent. The panel majority have refused to apply AEDPA's highly deferential standard of review. Panel majority's errors have real consequences. The state of Ohio must retry Smith for a crime committed nearly a decade ago. That result comes at a steep cost for both society and the victim. Retrial diverts significant time and resources away from other law enforcement activities. The decision below is the latest in a long line of Sixth Circuit AEDPA errors. This court has reversed the Sixth Circuit at least 24 times for misapplying the statute, and these reversals only scratch the surface of the Sixth Circuit's defiance. I would have summarily reversed the judgment below to ensure that the federal courts do not exceed their very limited role in collateral review of state criminal convictions. So second, and finally, I say all of this by way of criticism in this particular case, and the like, not as someone who thinks that there is no role for the federal courts in habeas review. I think plainly there is, both as a matter of history and tradition in terms of what the writ has been, and even post AEDPA 1996 within the strictures that Congress set. In 2022, I published an article outlining a path, a limited path, admittedly, but I do think there's a role for some statutory reforms to make federal habeas review more readily available in certain cases. So I'm not here as an opponent, necessarily a knee-jerk opponent of habeas relief in all cases. My concern is this at bottom. Decisions, actions like what you see from the Sixth Circuit in this case lead to the equivalent of Newton's third law, right? Every action has an equal and opposite reaction. And in my view, I've made perfectly clear, both in my original decision, both in my writing on the conditional writ, I think the Sixth Circuit is wrong. They're entitled to be wrong in our system, and that's fine. I accept that. But when courts stretch the law or engage in motivated reasoning to reach particular results in particular cases, other actors in the system react against that, and that distorts the system. In the end, in my view, faithful application of the controlling statute not only best safeguards, but is the only safeguard for the important interest that the writ serves in the cases where it's actually needed and necessary, where it is actually truly needed to vindicate those who are actually innocent, for example, or to prevent a manifest miscarriage of justice. So anyway, with that, we have time for some questions. Hoping to leave some time. Yes.
So with respect to federalism, if you have a case where this satisfies the statute, is that a normal kind of relief, reversal of conviction remanded to retry without the correct law?
Yes, I mean, pretty typically the successful writ, I mean, the Supreme Court today granted a writ, affirmed a writ in the Glossop case, capital case, and they remanded for a new trial. So pretty typically that's the that just gets you into discussions about, you know, double jeopardy and the fairly typical standards on that. Yeah.
I noticed that Smith represented himself. Some part of the case.
He had counsel in federal court.
Okay. So, well, I was wondering about the.
Always better to have counsel.
He filed
Perhaps, I mean, most habeas petitioners are pro se, but he did have counsel. If you had asked me, I would have said by memory, although I have not looked at it in a couple of years, that it was retained counsel and not appointed, but I could be wrong on that.
I'm wondering about. So, to what extent is that disadvantage them? Since they don't want to.
Well, so here's the thing, habeas practice is factually and procedurally incredibly involved and difficult. So if you imagine, like I highly simplified this, gave it to you as quickly as I could. There's a lot more going on in this case and so forth. And if you just were actually to start thinking about, you know, a reasonable hourly rate, for example, maybe even a substantially discounted hourly rate, like nobody can afford it, honestly. Which is why in a case like Glossips, I don't know who's representing him. It might be a public defender. It might, whoever it is, it's not somebody who's actually being paid. So the overwhelming majority of time, that's going to be the case. Also, I would say the overwhelming majority of these are pro se. That creates a lot of difficult challenges. Everybody would always benefit more from having counsel. I would benefit more if they had counsel, as frankly, my time in practice, you're always better off with good opposing counsel. It makes your job so much easier as a lawyer than having bad counsel on the other side of the V. So everybody would be better off in that world, but that's just not where we are, unfortunately. Yeah.
Connor, can you talk about two different sets of factors? The first, what to use and to what extent when you choose to adopt a magistrate's R&R. Second, what you use to determine whether you should certify or deny to appeal your.
Yeah, so the report and recommendation from the magistrate judge is governed by 28 USC section 636. So there's a series of the standards of review in there and procedural requirements and so forth that generally serve a narrowing function. So typically in habeas, for example, you might have 4, 6, 15 grounds on which the petitioner seeks relief. The magistrate judge presumably would deny all of those, but you might get objections only to 2 or 3 of them. So it really is a funnel to help narrow the review, and there's requirements about when and how you object and so forth. So then if the objection's proper and sorry. It's de novo review on proper objections. So you just review, as if you didn't have the benefit of the work of the magistrate judge. In terms of granting a certificate of appealability, again, there's no right to appeal as the petitioner. It's asymmetrical. If the district court grants a writ, the state has an automatic right of appeal by statute. The petitioner has to ask if it's denied. Now, frankly, that makes a certain amount of sense, right? Because you get all of these petitions, the bar is very high, and the bar is so high that the issuance of a writ is the exception rather than the rule, and is pretty rare. So Congress said, rightly in my view, that the courts of appeals don't need to handle review of every single one of these. So what I would say is there's a standard in the statute in 2253 about whether any fair-minded jurist can reach contrary positions and so forth. And it's not really a merits-based determination. It's about really whether, in my view, there's a substantial question that's fairly debatable. So in this case, I thought one of the factors that played into my mind was that the state intermediate appellate court decision was 2-1. And so there is something debatable. And look, I mean, I'm not going to sit here and say that the police detective in this case did a great bang-up job, but that's not the test.
Good afternoon, Judge. My question to you is there a different standard applied between issuing a full writ or a conditional writ upon source to your discretion, or how does that, is there anything that differs with that?
Most writs are conditional, then they become unconditional if the condition is not satisfied. So here the condition is state has to retry without use of the identification by March 13th. So then on March 14th, the unconditional writ becomes conditional. Yeah.
So say we believe AI when it comes to the reversals. If the Sixth Circuit keeps getting reversed by the Supreme Court when it comes to habeas review decisions, but they still keep bringing out these decisions, what is it that they're using as interpretation in order to still come to these same decisions when it comes to habeas review?
So look, in this case, in my view, you can go read the Sixth Circuit panel decision for yourself. You can read Judge Thapar's dissent. You can read Justice Thomas, whatever you want. You can form your own opinion. Sincerely, my belief is that the two judges and the panel majority just did an independent de novo review of the record presented in the state trial court. They would say that the state intermediate appellate court, that no fair-minded jurist could do what they did, but I don't think that's right, and I don't agree with that. I think it's difficult to on this record. So, I think it's not that necessarily there's particular act or just closing their eyes to the standard or the like. Although I think that happened in this case, there's no language about this aspect of what the state intermediate appellate court did is unreasonable. It's an unreasonable application of Biggers, and that's the standard. It's hard on a totality of the circumstances test, it seems to me, to have an unreasonable application at the end of the day, where the state court says, here's the totality of the circumstances, and we're reviewing the totality of the circumstances and come to the following determination. In that world, that's really hard to do, it seems to me. It's not clear to me why. I think it's certainly possible that even in that world, you could cross the line, but I look in vain in this case for a principled reason of that. This goes right back, you probably don't read it anymore. I believe he was a judge at the time. Scalia wrote a famous article called "The Rule of Law is the Law of Rules." So, what do you want, balancing tests, or do you want bright line rules? If you have bright line rules and the state court's on the wrong side of it, that's part of 2254, right? Contrary to determination by the Supreme Court. But if it's unreasonable application, that's hard, and it gives courts much more discretion to do what they want to do, as opposed to recognizing principles, for example, of federalism or comity or finality, none of which got a mention in rules. Yeah.
Speaking of the rule of law, we're living in a pretty extraordinary time. Constitutional law, introduction of presidents being replaced in what's the practical role of enforcing the rule of law when there seems to be some encroachment in the executive branch?
I am not sure I would accept the premises of the question, but I think ultimately the question is that if I have a case or controversy in front of me, I'm faithfully to apply the law. And you take an oath without fear or favor to do justice without regard to persons. It doesn't much matter if the person in front of you is, poor person, who lives 20, 30 blocks from here in a bad neighborhood suing Key Bank. Key Bank's in the wrong, and the law favors that person. You rule in front of them. And same thing. I'll hazard the guess that in the controversies to which you're referencing, the administration will win some and lose some. That's, I don't know about the merits of any of them. Frankly, I'm too busy to pay much attention, so I really don't know. Even if I did, I wouldn't wade into the merits of any of them. But as long as those are, the faithful applications of generally applicable neutral laws. Let justice be done, though the heavens may fall.
So cases during, like, shortly after 9/11, were there changes to procedures or processes as a result of that, or it relatively stayed the same?
Yeah, not really. The last word on habeas from Congress was in 1996. There's really not been amendments to the statute since then. The cases you're referencing, candidly, I'm not all that familiar with. It involves a lot of the Guantanamo detainees and military tribunals and things like that. I've read them, but they're not ones that I deal with every day, so I'm not quite so fluent on them. But there is a body of law around those. I think it all goes back to what Ex parte Milligan or something. Yeah.
Your Honor, I appreciate you extolling the virtues of dual federalism, but to whatever extent you're comfortable, can you talk about the competency of state courts and your experience in reviewing habeas?
Yeah, so I mean, there's a difference in my view between the theory and the practice on this, and it's a tension, right? Under Article 3, the judicial power is vested in one Supreme Court and in such inferior courts as Congress may from time to time gain and establish. So under Article 3, Congress doesn't have to create a federal court other than the Supreme Court at all. And in that world, what would happen? If you thought that your right to counsel was violated, if you thought that you had a confession coerced out of you, what would you do? Well, you would raise that issue in state court. So it seems to me that as a matter of federal constitutional law, the Constitution, Article 3 presumes that state courts and federal courts are equally as capable of vindicating whatever federal rights the Constitution and laws of the United States establish. In practice, I think we all know that's not entirely how it works. You know, once you get out in practice, and to the extent you've been doing externships or part-time employment while you're in school or summer clerkships and so forth, one of the things you very quickly struggle with all the time is, well, how do we forum shop? And I don't mean that in a negative way. You ought to be forum shopping. Where would you rather be? And in the law, our procedural rules give plaintiffs and defendants the opportunity to forum shop or another. So you ought to be, you're not doing your job if you're not shopping. Okay. So you got to think about those things. Sometimes you want to be in federal court, sometimes you want to be in state court. There's different advantages and disadvantages depending on who you are and what the issues are. I think when it comes to criminal cases, by and large, people, if you're charged with the offense and what you care about is procedural justice, you probably want to be in federal court. The unfortunate corollary that goes with that, if you are charged in federal court, that means that the government probably has you dead to rights and you're on tape 3 ways to Sunday. You probably don't have that much to work with. So it's really easy in that world to honor procedural rights because it's going to all end up in the same place anyway, in all likelihood. State courts are much higher volume, right? You're in Cuyahoga County, 34 state court judges. I couldn't even tell you the case filing statistics offhand, but it's way, way, way higher in state court than federal court. And so it does lead to just a much quicker system of dealing with these issues very quickly as they come up. And so that is one of the things that comes into play here, which is why at some level the statute 2254 looks at the state court adjudication as a whole, and you don't focus on, well, what did the state trial court do? Well, the state trial court may literally have written one sentence, motion denied, or something to like, maybe not much more than that, but that's why you look at the state record as a whole.
Good place to stop, guys. I'd like everyone to thank Judge Calabrese for speaking with us today. So please grab a sandwich on the way out. The judge knows we're going to go to lunch, but he's going to be here for a few more minutes. We have next month, we have a debate coming up on the new rules of Chevron, and we have post-Chevron world. So come see us on that. Well, thank you, guys.
Thanks, everyone.
Very much enjoyed that.